5 seconds to go. Start. Having given our anxious thought to these facts, we are of the considered opinion that the prosecution has failed to establish the charge of criminal breach of trust against the appellant beyond a reasonable doubt. We are inclined to agree with the learned senior counsel for the appellant that the known examination of B. Satyajit Reddy has been materially fatal to the case of the prosecution. Furthermore, it appears that B. Satyajit Reddy was deliberately not examined, as he would have deposed against the prosecution. Undoubtedly, some of the proven facts, like deposit of interest amount from the account of the appellant to that of B. Satyajit Reddy, do create a strong suspicion against the appellant, but as held by this court time and again, suspicion cannot take the place of proof, howsoever strong it may be. We are therefore of the firm belief that in the absence of cogent and unimpeachable evidence to prove that the appellant has misappropriated the funds of the bank and or of B. Satyajit Reddy, it would not be safe to convict him under the provisions of section 409 IPC. So far as the charge under section 420 IPC is concerned, once again the best and the only person who could throw light on whether or not he had voluntarily agreed to transfer his FDR amount in the account of the academy, or there was an element of inducement, cheating, or a false promise, was B. Satyajit Reddy himself, who has chosen not to enter the witness box. In the absence of even an ordinary complaint by B. Satyajit Reddy regarding misuse of his FDRs, it will be too far fetched to hold that the appellant had any mens rea to deceive or to misappropriate or destroy valuable property of B. Satyajit Reddy. We may at this stage briefly note that learned senior counsel for the appellant had raised another contention, namely that the charges under section 409 and section 420 IPC cannot go together. He eloquently argued that the essential ingredients of the two offences are conflicting in nature. Section 409 or 405 IPC deals with offences where the accused has been entrusted with the property, and section 420 IPC deals with offences where the accused has dishonestly induced the victim complainant to depart with the property in question. It was therefore argued that an accused cannot be charged under both the sections simultaneously. This contention, however, has been rendered academic in the light of the aforestated discussion and conclusions. We thus do not express any opinion and leave this question open for adjudication in an appropriate case. Having held so, we hasten to add that the appellant acted brazenly contrary to the norms and internal instructions of the bank. Although he was clever enough to not trespass into the prohibited areas of sections 409, 420 and 477A IPC, he ran the risk of causing financial loss to the bank, despite his subsequent act of depositing the interest accrued upon the FDRs of B. Satyajit Reddy from his personal account and thereby absolving the bank from such liability. The actions of the appellant constitute gross departmental misconduct and are unbecoming of a senior bank officer. The management of the bank rightly lost faith in the appellant, and the punishment of dismissal from service imposed on him wide order dated 6 January 2006 on the basis of his conduct which led to his conviction by the trial court is fully justified. In the peculiar facts and circumstances of this case, there was no legal necessity to hold any departmental inquiry to reiterate the same factual conclusions which have surfaced during the course of criminal trial. Such findings, though, may not be sufficient to fasten criminal liability on the appellant. His dismissal from service of the bank is fully legitimized, and the punishment so awarded is proportionate to the proven misconduct. We say so also for the reason that neither can the appellant be allowed to take undue advantage of the benefit of doubt being extended to him, nor is a recourse to a departmental inquiry desirable at this belated stage. On the other hand, upholding the order of dismissal dated 6 June 2016 will serve the cause of public interest and send a befitting message amongst the appellant's peers. We are also constrained to observe that in this case, the CBI has either adopted a casual and callous approach, or there was some hidden pressure to derail a fair investigation. Stop.